I again, okay. Welcome everyone to our Paralegal Student Alumni Association seminar on sports law, brought to you by Professor Bruce Allardice. I have a little bit of a bio, and then I'll let him take the stand. Professor Allardice recently retired as a professor of history at Suburban College. For the last 2 decades, he taught European and American history, as well as political science. A law school grad, Bruce has authored or co-authored 7 books. Okay. 7 books and over 100 articles on American history, sports law, and political science. He is a 2-time winner of the McFarland Award for Best Baseball History Article of the Year. Bruce works with John Thorne, Major League Baseball historian, in researching the early history of baseball. And we're so grateful for Professor Allardice to come back here to South Suburban, even though he's retired, and share all of his wisdom with us. We are so grateful. Thank you, Bruce.
Thank you, Becky. Okay, we'll get started. Let's see if I can share the PowerPoint here. There we go. Can you see it okay?
Yes.
Okay, that's good. And hear me okay? Okay. By the way, I'm doing this from my computer room here, and this is part of my library in the background. For you students there, you can see I read far too much and far too many books. There's about 1,000 books back here, so don't be like me. Okay, well, thank you again for inviting me to speak today. I'm going to speak today on some aspects of the interaction between professional sports and the law. Now, I'm not going to touch the amateur sports. That could be a whole nother 45-minute presentation or something like that. All the college stuff and high school stuff and everything. I could be starting out with a few instances of cases of sports law that have made it to the Supreme Court and that impact all professional sports. Then I'll turn to baseball, which is sort of my hobby, I guess, and in particular the Chicago White Sox and the 1919 World Series scandal. And I'm going to bring out and add some of the practical aspects of law that you might feel of interest. And I'll finish up with some issues that have been arising in just the past couple weeks. Give you a bit of context. Professional team sports with paid players and paid clubs and tickets and everything, franchises, businesses, is pretty much an American invention. It was Americans who found in baseball a sport popular enough they could charge people admission, they could pay the players, they could afford to build stadiums, enclosed stadiums where they could charge that admission. They could do this. Not Europe and the rest of the world didn't do this at the same time. They still lag behind the United States in professional sports franchises. Today, sports is one of the major United States industries, with annual revenues in excess of $40 billion just for the big 4 sports: professional baseball, football, basketball, and hockey. Not even counting the other sports. 40 billion right there. American sports have a worldwide interest, worldwide media reach, worldwide coverage. It is estimated that people wagered $120 billion last year on professional sports. By comparison, the state of Illinois tax revenues are about $50 billion a year. People are betting more on sports than the state of Illinois government gets. $120 billion, that's bigger than the gross domestic product of most of the countries of the world. And baseball has 5 times the revenue of McDonald's hamburgers. Which leads us to a fun quiz here. Who pioneered the franchise model, business model in the United States? Was it McDonald's, Pizza Hut, Walmart, or the National Baseball League? Well, as you might guess from the theme of my talk topic here? The answer is, of course, Major League Baseball. A professional baseball league was started in 1871, but it was mostly run by the players and didn't have much organization. So in 1876, a Chicago businessman by the name of William Hulbert decided to change all that and create a new league of professional teams. His model included local teams owned by local businesses, but with territorial franchising. In other words, he would organize this on a national level, but he'd parcel out franchises to, one franchise for Chicago, one franchise for St. Louis, one franchise for New York City, et cetera, et cetera, et cetera. And this would eliminate the ruinous competition that early teams had. McDonald's did not invent franchising. This was 70 years before McDonald's did franchising. McDonald's might have perfected franchising as we know it today, but Major League Baseball actually started the business model of franchise. Sports, I think, is a great tool for teaching people about the law. For better or worse, sports in the United States is subject to laws, just like other activities of businesses. And sports involves every aspect for the law: business law, labor relations, lawsuits, criminal law, ADA compliance, taxes, and government. All these are part of the law, and in fact, there are several colleges that have courses specifically on sports law and sociology and history. Oops. Sports is so important, it's actually made it to the Supreme Court. There's this, by the way, it's not those Supremes on the right. That's the old Diana Ross and the Supreme singing group. Yeah, it made it to the Supreme Court. Yeah, there's been a couple cases in the Supreme Court. First of all, probably the biggest case is involving the Sherman Antitrust Act. And under the Sherman Antitrust Act, which was passed in 1890, 2 or more businesses were prohibited from colluding with each other if they operate in different states. I'm simplifying greatly there. They can't fix prices. They can't have phony competition, basically. And the enforcement of the act reaches the apex in 1910, when the Supreme Court said that Standard Oil was in violation of this antitrust law, that it was a monopoly, and it had to be broken up into Amoco and Standard Oil of New Jersey and all the rest of these things. Well, in 1922, the U.S. Supreme Court was faced with a case about baseball. There had been a third baseball league attempted to be found, the Federal League, and they sued Major League Baseball, saying that it was a monopoly, that it violated the Sherman Antitrust Act. However, the Supreme Court disagreed. They wanted to keep baseball prosperous. They didn't want to change baseball, certainly. And under existing law, laws existing 100 years ago, they said that baseball is not interstate commerce. Even though the teams travel from one state to the other to play, this is incidental, according to the Supreme Court, to its business, which is basically staging local exhibitions of sport. That these teams, these franchises are independently owned and operated, even though they're part of the umbrella baseball thing. Therefore, the antitrust laws didn't apply to them. This issue was relitigated in 1969. Curt Flood, a baseball player, sued to basically be made a free agent. I'll get into the contract law part of it later. But the Supreme Court in 1969 said, we're going to go by the 1922 decision and say that baseball is not interstate commerce, sort of. Now, this illustrates a legal principle I'm sure you've heard many times. It's called stare decisis. And stare decisis is a very fancy Latin legal term. You know, the law, there's a lot of Latin involved there for reasons that are pretty obscure. But basically it says we're going to follow old decisions, whether we agree with them or not, in order to keep the law consistent. And if there's changes in the law, the legislature should do it, not the courts. And so basically they said, okay, well, we're really sort of not happy with it being declared not interstate commerce, but we're not going to really change the law. Couple things here. First off, none of the other professional sports have this exemption. Football, basketball, hockey, they're exactly the same interstate teams traveling from one state to the other, same model, but only baseball had this exemption. And that's because baseball was the first professional sport to litigate to the Supreme Court. Basically, they got a grandfather clause, I guess you'd say. This case also illustrates how the law can be changed based on the facts. Now, in 1922, it could be argued that professional baseball was local because most of its ticket revenue was ticket sales, in the city itself. Chicago was Chicago revenue. And the clubs got 90% or more of their revenue from local ticket sales, not involving interstate commerce. But these days, the factual situation has changed for baseball and other sports. And today, teams derive most of their revenue from national TV contracts. In other words, you're seeing Chicago Cubs baseball in Los Angeles and New York and every other state in the nation. It can't be plausibly maintained anymore, in my opinion, that baseball is local and not interstate commerce. So with that change, if this legal issue ever came to the courts again, I'm sure the Supreme Court would reverse its 1922 decision based on changing facts rather than the fact that they're changing the law by themselves. And this has an impact on baseball and sports too, because every time a politician doesn't like something that happened in baseball, which is quite often, by the way, they threaten to go to Congress and pass legislation to remove baseball's antitrust exemption. So baseball has been very sensitive to trying to accommodate local political and sports interests in order to avoid this legal decision, to avoid getting a decision against them in the first place. I'm going to turn to golf right now for another case that made it to the Supreme Court. And this is involved with Disabilities Act. Now, the Professional Golf Association, professional golf stages tournaments, and the rule is that the players, the professionals, always have to walk the course. Now, amateurs and that, they have a golf cart, which I've shown illustrated here. Well, it came up about 20 years ago. A partially disabled golfer, Casey Martin, had been a college golfer. He sued the PGA to be allowed to ride in a golf cart during the tournaments. This actually brings up the question, who sets sports rules? The sport itself, the sports governing body, the Professional Golfers Association or PGA, or the government? In this case, went to the Supreme Court. And the Supreme Court actually got testimony from the top golfers in the world. Jack Nicklaus, the greatest golfer of all time, arguably. He said, walking is part of golf. You walk about 7 miles, and it tires you out a little bit. They testified in favor of the rules, and they said this shouldn't even be a legal issue. However, the Supreme Court said it's a legal issue. Well, they're lawyers, they're probably not golfers. And so they decided that and said, hey, you got to allow this guy to have a cart if he wants it. So that was the rule. As it turns out, he wasn't a good enough golfer to be on the pro tour anyway. So it's sort of, a moot point. But the principle was involved that the Supreme Court will decide who can play golf. Well, you probably heard in the news about the proposed new White Sox stadium. And this is a proposal, it's been in the news a lot. It's part of a big development, which is planned. It's for a parcel of land called the 78 in Chicago. It's called the 78, by the way, because there's 77 historic neighborhoods in Chicago, and this is planned to be the 78th. It's basically an old railroad yard that needs environmental cleanup, and that hasn't been used, but it's been talked about for years. It's just to the south and west of where Chinatown is, if you know where that is. And the proposal is for a big development, including a new stadium for the Chicago White Sox. It includes a stadium, it includes hotels, it includes residents, it even includes a so-called research laboratory. Now, the developers of the site, including the White Sox Stadium, just think of the legal issues and legal hurdles they have to navigate to get this thing done. Zoning laws, building codes, environmental cleanup under state and federal laws. People are going to be suing them to stop the development. Now, you, as budding paralegals and lawyers, ought to be happy about this. It means a lot more work for lawyers and paralegals. It's a job. Yeah, it makes work for you. So you ought to be supporting all this legal mess. But another aspect of that is the partnership between sports and government. Now, this proposed stadium is the proposal upwards of $1 billion. The real estate, this big real estate company that's proposing this in partnership with the White Sox, and nobody has $1 billion privately. Now, government and law and sports do partner all the time. The current Comiskey Park was financed in part by sales tax. The sales tax imposed on Chicago hotel guests. Basically, they issued bonds to borrow money to finance the construction of the stadium, and the bonds are being paid off by this hotel tax on people staying at Chicago hotels. Now, most of them are Illinoisans, but some of them are out-of-state people, of course. And of course, this tax was supposed to be temporary. It's supposed to, when the bonds were paid off, their taxes are going to be gotten rid of again. Now, as with most taxes during history, the politicians always say it's temporary, but believe it or not, it magically becomes permanent. And part of the proposal for this new financing of this stadium is that they're going to extend this hotel tax in order to help pay for the infrastructure developments for this new stadium site. This is one of the proposals that they've had is very, very innovative. Basically, they're saying that developers, including the White Sox, can keep all the sales tax that's going to be generated by this new district. Now, I'm going to get into tax increment financing in a bit, but this actually sort of harkens back to the 1700s in France, where the French monarchy, to raise money fast, would basically borrow money from a bank or a private individual and say, to pay it off, you, the private individual, can collect a sales tax, the salt tax, for example, in France. Now, this doesn't have a glorious history. Among other things, this helped to cause the French Revolution of 1789, which overthrew the government. But this is just one of the ideas being proposed here. But a slightly different idea is something called tax increment financing, which I hope you've been exposed to in your classes. Illinois law allows for something called tax increment financing. And that's probably going to be part of the final package if they try and get this proposal done. Illinois law allows units of local government to designate areas within their jurisdiction as tax increment financing, or TIF, districts. In fact, in Chicago, about 1/3 of the property taxes in Chicago are devoted to these TIF districts. So it's a big, huge business. When a city designates an area as a TIF district, the property value of all the real estate within that boundary is designated as the base value. Okay, we have property taxes. And this is the amount that's set, and any property tax or value increases and thus tax increases after that go into a government fund or a quasi-government fund to help develop, in theory, the economic development of that district. It's an economic development that, at least in theory, is supposed to pay for itself. Whether it does in fact or not is another question. The city can use this pot of money to lure local investors. They can give low interest loans, for example, to new businesses relocating in that district. Well, in this case, most particular businesses not relocating in this new stadium development, this 78 district. And the idea is that the city and the government, through laws, establish a public-private partnership for economic development. In this case, the economic development of the Chicago White Sox, but also of Chicago as a whole. So these districts, the sales taxes, the extra sales taxes, in this case, there basically are no sales taxes right now because there's no business. There's no businesses in the 78 district. And of course, the property tax revenues, and basically there's very, very little property tax revenue right there. They will be devoted to essentially financing the development. They can use it for redevelopment of old buildings, for example. It's been used for public infrastructure, not just roads, but sewers and electric lines and that. Pollution and environmental cleanup, which will be an issue in this thing. Rehabilitating historic properties. Again, government partnership with sports is nothing new, but it's a creature of law. Whether it's desirable is another question. I'm not getting into that, but it is a fact, for better or worse. Now, some cities actually give their sports teams a direct subsidy. Here's $300 million to build a new stadium. Wouldn't you like the government to give you $300 million to build your business? Anybody object to that? No, I didn't think so. Others give the sports team tax breaks, like they don't charge, property tax for the business, or they allow essentially the sport team to use the government's ability to issue tax-free government bonds, or tax-exempt government bonds, I should say. I suspect this new Chicago Stadium proposal will involve all three of these aspects and probably more. Here's another one, the safety of the fans. And this is one that's gotten to the Cook County courts here. As you know, baseball, balls are hit into the stands. Those are pretty hard baseballs, and they sometimes injure people. Can a fan sue the Chicago White Sox or the Chicago Cubs if, when attending a game, they get hit by a foul ball and get injured? Now, whenever you go to and this will go into, there's contract law liability here. Usually, or quite often, the tickets historically, the tickets you got had a little language on the back. Nobody ever reads these tickets on the back, but they got, 2-point type or something, which you can't read unless you're got a microscope. And historically, they said you can't sue the club if you get injured by a foul ball. They're disclaiming liability. You assume this illegal concept of assuming the risk. If you go into a stadium, you assume the risk that you're going to be hit by a foul ball. First of all, is this a contract? And is this a legal enforceable contract, more importantly? By the way, clubs, I'm getting into the contract in a second, but clubs have basically put nets out for protection to try and stop the lawsuits, to stop the problem from even happening in the first place. They don't even want to get it into the courts. And so you go to a baseball game, you're going to, professional baseball, Sox Park, White's, Comiskey Park, Wrigley Field, you're going to see those nets there. The tickets generally claim a waiver, or they specify what you have to do to bring a lawsuit if you get injured. And recently, the First Appellate Court in Chicago addressed whether this type of waiver was enforceable after a person brought a lawsuit against both the Chicago Cubs and Major League Baseball. There's another aspect of the case here. If you're trying to get money in a lawsuit for personal injuries, you try and sue as many people as possible and try and sue the people with the big bucks. Obviously, Major League Baseball and the Chicago Cubs have the big bucks. They were injured. Got a fractured bone from ticket. And the lady who was suing, it was a gift ticket from her father. She didn't even pay for the ticket, but she spent 4 days in the hospital. And of course, by the way, the Cubs are going to pay for the hospitalization. That's not the question. But the lawsuit asked for injuries. Now, Major League Baseball and the Cubs moved to dismiss the suit at the outset, claiming that she had no legal right to sue based on the contract terms issued on the back of her ticket, warning at the Cubs or other entities, i.e. Major League Baseball, would not be liable for any injuries. The back of the ticket also directed attendees to the Chicago Cubs website for full terms and conditions that amounted to a waiver of a patron's right to resolve a dispute through a court of law. Basically, they're saying, not only aren't we liable, you can't even sue us under this. You got to go to arbitration. Cook County Judge Kathleen Flanagan ruled against the Cubs in Major League Baseball and allowed the lawsuit to stand. She ruled that the terms and conditions on the ticket were procedurally unconscionable and therefore unenforceable. Major League Baseball and the Cubs appealed to an appeals court, but the appeals court backed the trial judge. They said that this ticket basically referred you to a Cubs website for the arbitration, and it was basically so long and nobody ever went there that it amounted to an unconscionable thing that shouldn't be enforced against a ticket holder. They also said the ticket did not specifically mention the waiver of those rights, therefore supporting the conclusion that she'd never been made aware of the rights, had no negotiating power to negotiate a different ticket term, and therefore the contract was one-sided and thus unconscionable. And the suit was allowed to continue. Well, this is a subject that I've written a lot about and has a lot of legal angles. It's called the Black Sox scandal. And it goes all the way back to 1919 when the Sox, who are a much better team than they are today, by the way, won the pennant. They were favored to win the World Series. But 8 players on the team decided to throw the World Series to make some side money. They conspired with the gamblers. Basically, the bribe was $10,000 to throw a piece to throw the series. They threw the series. The Sox lost the series, and it was suspected at the time that this was going on, but they didn't find proof until just about the end of the next season. The club couldn't prove that they'd thrown the series at the time, so they re-signed them to 1920 contracts. They played most of the season, and basically in the last week of the 1920 season, the players started confessing. The White Sox immediately suspended the players, and it went to trial. The White Sox players were found not guilty of conspiring to defraud the public at the trial in 1921. But nonetheless, Major League Baseball barred them from playing forever. Now that's the background. There's a lot of legal questions here, but just know that, first of all, there was so much double crossing. The players never actually got most of the bribe money. The gamblers who paid the bribe money paid them to the first baseman on the team, and the first baseman was supposed to share it with the other players, and he didn't. He pocketed the money himself and then retired. There's no honor among thieves, basically. One of the questions involved was, who can suspend the players? Now, this is a clear violation of baseball's rules, but who had the power to enforce those rules? The club or the commissioner of Major League Baseball? more legal rules, was throwing a ball game against the law at the time. No, it wasn't. Not in Illinois, in most states at least. It was against Major League Baseball's rules, but there was no rule specifically saying you had to play an honest ball game. And this, of course, for all sports, not just baseball. And this made it very difficult to punish the players under law. They had to essentially, Cook County grand jury and the presiding justice of the Cook County court basically came up with a novel legal theory that they had conspired to defraud the public. They hadn't actually defrauded the public. It's conspiracy, not the actual defrauding. And there are a lot of legal issues involved here. First of all, this was a complicated and novel legal theory, and they had 12 jurors who basically had a hard time understanding exactly what law the players had violated. And secondly, the people indicted and in court during this trial were the players and the low-level gamblers, but the big money gamblers, the guys who actually bribed the White Sox, were not on trial. So in practice, the jurors said, hey, these ham and egg gamblers who just heard about, the fix and decided to get out on it, but weren't actually involved in the bribery, were being indicted. But hey, why not the big game? Why aren't they in court? There was sort of a class, resentment here that the small fry were being indicted, but the big guys had gotten off scot-free, and I'll tell you why they weren't indicted in the first place. But more to the point, another thing was the legal issue. Under Major League rules, all you had to do was conspire to throw a game. You didn't actually have to throw the game. Major League Baseball didn't have to prove that you actually, struck out deliberately or deliberately fumbled a ground ball. All you had to do was participate in the conspiracy and not report it to the team. But the defense, the White Sox lawyers, or the Black Sox lawyers, they were called the Black Sox, by the way, the eight players who tried to throw the game, emphasized there had to be proven an intent to defraud the public, and not just to collect money on the bribe. And this was a lot more difficult. Obviously, if you're accepting money to throw a game, your intent is to take the bribe money. But proving they were trying to defraud the public rather than just line their own pocketbooks is another story. And the judge's instructions to the jury after the trial was over emphasized that there had to be, the prosecution had to prove this intent to fraud the public, not just the practical aspect that they defrauded the public, which they clearly did, but they had intended to do so. And that made the acquittal essentially inevitable. Remember, this is a jury of Chicago people. A lot of them were White Sox fans. They were going to look for an excuse to make the White Sox not be prosecuted, to be there, find them not guilty. In fact, after the not guilty verdict was entered, the White Sox and the jurors both adjourned to a local bar and had a big party together then. I mean, that's, it's sort of ridiculous, but about impartial justice, but that's one of the practical aspects of the law. You're not going to be able to prosecute popular local people, or you're going to have a very difficult time doing so. There were a lot of other things going on too. Among other things, the White Sox had confessed to the grand jury. Three of them had to confess that they accepted bribe money and played poorly. The confessions were stolen, and nobody knows to this day who stole them. The ones they actually signed and everything. But we know who stole them. It was the gamblers who stole them. Big money gamblers who stole them. The thing is, they still had the court stenographer transcript of the confessions. But under the law, if it's a transcript rather than a signed thing, at least at the time, the confessions could only be used against the person who did the confession. So in other words, Joe Jackson, let's say, one of the ball players said, yeah, I conspired with 7 other guys to throw the game. Well, that could only be used against Joe Jackson rather than the other 7. And in fact, they had to delete the names of the other 7 in this testimony. So you're seeing these confessions being being read out to the jury. And Jackson confession, Jackson, I conspired with player X, player Y, player Z, player A, B, C, D. And it's a long confession, and the jury was just so bored by all this dull reading and not using the names that they just fell asleep, basically. Another aspect of the trial was that some of the proof was literally so weak against some of the peripheral gamblers that after the trial was over and the jury went out, the judge basically said, okay, there's 3 or 4 minor league gamblers here. I'm going to direct a verdict of not guilty because the state just didn't prove its case. Jurors are human. And that should be recognized by any legal field and any lawyer. Now, my friend Bill Lamb, who's written a book, the book on the trial of Black Sox in the courtroom, which I show you the thing there, he says, he was a former prosecutor in New Jersey. He said that clearly the 3 Black Sox players who confessed were clearly guilty and should have been found guilty by any impartial jury. We'll be talking about some more jury stuff in a bit. This case was prosecuted in Chicago, in Cook County. But remember, they threw the World Series. It could have been prosecuted in Ohio, too. Cincinnati, they were playing the Cincinnati Reds in the World Series. Okay, they threw games in Cincinnati as well. The conspiracy was born in a New York hotel. So we have venue questions on this, too. If they broke the law, where should it be prosecuted? In New York, where the conspiracy first started? In Ohio, where they threw some of the games? Or in Chicago? They chose Chicago, first of all, because Cincinnati couldn't care less about, Chicago players being thrown off the team in New York. They couldn't care less about it anyway. Plus, of course, the witnesses and the players mostly lived in Chicago and they're more available here. So Chicago was considered to be the venue. But there were other venue questions involved. For example, the New York gamblers that financed the series, basically Arnold Rothstein and Sport Sullivan and Abe Battle, they weren't brought to trial. And in fact, there was extradition difficulties here. Abe Battle was a former boxing champion who was basically Arnold Rothstein's bad man. He was the guy who financed the series. The other guy in Chicago said, yeah, I saw Abe Battle. He was bribing the ball players. So Battle was a New York resident, so they went to New York to get extradition. And believe it or not, the same witness who said Abe Battle, I saw him bribe the players. When he got to New York, at the New York court, he said, Abe Battle? I don't know who he is. And so they couldn't extradite him because he said that must have been another Abe Battle, not the boxer. And of course, what happened was that the gamblers bribed the witness $10,000 to basically forget that he ever saw Abe Battle. There was some of the other gamblers, they fled the country. They went to either Mexico, Cuba, or Canada. Okay, so you have this throwing of the game, throwing of the World Series. If they couldn't be caught breaking a criminal law, could they be sued? And if so, by who? By the fans who were denied an honest sporting event? Well, the criminal case sort of took that over. Okay, if so, how do you measure damages? The fans weren't entertained, I guess, one way or the other. They went to see a ball game, they went to see entertainment, they went to drink beer and all the rest of that stuff. How can you measure damages by saying, oh yeah, the guy made an error on purpose? What's the monetary amount there? Probably, or more probably, the idea of a lawsuit could have been by their fellow players. Remember, half the team was honest. And in a World Series, then and now, if you win the World Series, you get more money than if you lose the World Series. They take the ticket revenue from the World Series and divide it up among the players, and basically 60% goes to the winning team and 40% to the losing team. So each of the honest players who obviously got the loser's share were out about $1,500, which was a year's salary basically at that time by the losing. Could they have sued the Black Sox, their fellow teammates, for their lost share of the money? Here's a day. Well, first of all, how do you know that the Sox would have won if the eight had played honestly? How do you prove that? You see, in theory, yeah, they probably lost something, but how do you prove that they lost? That they would have won this series if those eight had played honestly. The Cincinnati Reds certainly would have testified, "Hey, we would have won the series even if the Sox had played honestly." And of course, they say that, by the way, to this day. So there's a lot of difficulties of proof there, proof of damages, proof of loss.
Bruce, were they favored to win? Were the Black Sox favored to win?
They were favored to win by a large amount until the day before the series, when the gamblers who had bribed the White Sox started to throw their bets in to the Cincinnati Reds, and then the odds became a lot more even.
Interesting. Yes, I think it's a
Uh,
really interesting issue in that case. Yeah.
Yeah, and one of the things about it was a lot of people noticed that the betting odds had suddenly changed, and that sort of first raised the suspicion that there was something wrong with the World Series. Now, this, by the way, was not the first World Series where rumors of players being bribed had come up. And in fact, in 1903, there was an attempt to bribe one of the players at the first World Series. The White Sox gladly went along with the bribes, or the eight players did. But in 1903, the pitcher who they tried to bribe said, "Get out of here, I'm going to punch you in the nose," and reported it to the team. So it didn't happen. Another aspect, taxes. There's another thing. Well, for example, the star outfielder for the White Sox, Joe Jackson, he admitted to getting $5,000 in cash. Several players admitted receiving actual cash. Several of them, by the way, weren't paid what they were supposed to, but Jackson said, "I'm not throwing unless you give me at least something down." So he got $5,000 in cash. He didn't report that on his income tax return. Yeah, the income tax was sort of new at that time. In theory, could the Internal Revenue Service have prosecuted him for non-reporting of income? Remember, that's what they got Al Capone on, the big Chicago gambler. It wasn't the fact that he murdered 38 people or anything like that. It's that he'd got money from all his illicit activities and never reported it on his taxes. So why didn't Jackson and the others get prosecuted? Well, again, in theory, they could have. But in practice and theory are a little different. The IRS then and now doesn't go into prosecutions that they don't think they're going to win. And here again, you're going to go into a prosecution. The jury's not going to be sympathetic just to the White Sox, but who wants to help the tax collectors collect more money? The fact that the case had gone kablooey in the Cook County Court, the criminal case, basically the IRS says, "We're not even going to try it because we're just going to lose the case." So they never even bothered to try and prosecute them. Another aspect, the White Sox players who were suspended, 3 of them had multi-year contracts. In other words, they were guaranteed, like $10,000 a year, basically, for the next 3 years. They're suspended and they don't get their pay. They sued the White Sox in 1923 for the pay that they were supposed to get. Now, this was a messy lawsuit. Did they win? Yes or no? The jury actually found in their favor, for reasons I'll get into in a second. But the judge basically voided the jury's verdict. because the White Sox players committed open and above board perjury during the trial. He said, I'm not going to reward their perjury by allowing them to win this case. Basically, the White Sox read out their confessions, and even though they'd already testified that they confessed, they said, oh, Joe Jackson, who's he? I don't know who he is. I never said this. You know, here's the legal document where you confess, and they pretended they'd never even seen the document. So the judge basically entered a judgment notwithstanding the verdict, which is a legal thing for saying, hey, I'm not going to reward perjury. Now, why did they win? A couple things going involved here. First of all is a concept called jury nullification. And jury nullification is basically saying the jury system was invented in part as a check against government overreach. And we're talking 1,000 years ago in England. And basically here, the jury said, you know, the White Sox are big and these are sympathetic players, so we don't care what the law says. We're going to find for the players. And then more particularly, something called condonation. And this is another legal theory. And condonation theory for a jury says that, legally says, the White Sox had rumors that these players had thrown this series, but they re-signed them for the next year. And the legal theory was that by re-signing them to the contracts and allowing them to play the next year, the White Sox were essentially condoning the conduct of throwing the World Series, and therefore they have no standing to say that they shouldn't pay the salaries anymore. Now, the upshot of it was after the judge directed a verdict of, against the players, the White Sox paid a few $1,000 and they dropped all the lawsuits here. Basically, by the way, the trial transcript was just printed and everything, and it's the most boring book you'll ever want to read. The lawyers are objecting to everything, every question the other side does. They read things 3 or 4 times over. If you're a juror, you'd be bored to death by these lengthy trials. Hopefully you'll never be a juror. Well, sports also involves contract or employment law too. And first of all, sports players' contracts. Now imagine, let's say you're being hired, or you want to be hired by a law firm. Imagine if you were contractually bound by your terms of employment in a law firm, that you couldn't leave the law firm without the law firm's consent. That they could basically employ you for the next year at your existing salary, and you couldn't go to another law firm. You'd probably scream bloody murder about that. But that was the situation in Major League Sports and Major League Baseball for 100 years. They called it the reserve clause. It's basically, this was a standard contract invented by Major League Baseball but copied by the other sports to reserve the rights of a player's contract to the team that originally signed it. Basically, it's an automatic 1-year renewal into perpetuity until the team doesn't want to have you anymore. Now, the player could refuse to play under those terms the next year, but according to the Major League contract, none of the other teams could sign that player. So in other words, you had to play for the team you were signed for, or just give up on baseball for a year. And of course, teams could trade you and all the rest of that stuff. Free agency we had today was non-existent. It was abolished in 1975. It was part of that Kurt Floyd lawsuit, which I talked about earlier. And also there was a hockey lawsuit by a new professional hockey league called the World Hockey Association. They sued the National Hockey League for a lot of things, but one of the attractions of this World Hockey Association was that their contract did not allow for a reserve clause. You were free, basically players were free agents. And that's what we have today in sports, a standard contract where the team can sign you for 5 years, but that's voluntary. And it's not, and after that, after you've served your 5 years, you can resign with your existing team, of course, but you can also be a free agent and go to another team if you want to. Then there's the so-called draft, the player draft. Now, again, you're a budding paralegal, budding lawyer. Imagine if all the law firms in the nation got together and held a draft and said, okay, Bruce Allardice, you can only work for this law firm and none other this year. We are going to decide who you sign with. That's basically the draft that we have today in sports. The draft, again, this is sort of unique to American sports, to allocate certain players, young players, college players, let's say, to professional teams. When the team selects a player, let's say a college baseball player, the team receives that exclusive rights to sign that player to a contract. No other team in the league may sign that player. And the only way that the only options the player can do is either sign for that team or sit out a year and then enter the draft the next year. And in addition to that, Major League Baseball's got rules saying if you're like a top player, your signing bonus is going to be $7 million, no more nor less. They not only decide who you're going to play for and what the time you're going to play for, but they also decide how much of a bonus you're going to get. Now, is this violative of all we think about as far as free employment, work wherever you want? Of course it is. The draft was started by football, not baseball, but by football in 1935. And it was started by football because the poor teams, the bad teams, were being beaten so badly by the good or the rich teams that they decided to have a draft and say the bad teams get to draft the best college player they want to. And then the best teams get, a draft choice way down the list. Basically to keep the competition a little bit more even. Now, is this anti-competitive? Of course it's anti-competitive. But of course, in practice, what happens? Who's going to complain? I'm a draft choice. I'm going to get a $7 million bonus. Not much reason to complain there. And the jury's not going to be too sympathetic to saying, oh, I could have gotten $9 million otherwise rather than $7 million. How are jurors making $50,000 a year going to be sympathetic to millionaires suing millionaires? It just ain't going to happen. It violates freedom of contract in many things, but first of all, the players like it, and the Major League Baseball Players Union is also in on this. And again, this is part of sports law, or the practical business of sports is the clubs and the players are not, they're antagonistic on some levels, but on other levels, they cooperate together. And this is, if you've got millions of dollars floating around, they just want to share those millions together. And if the ticket prices go to $40 a ticket or $100 a ticket, well, that's the ticket buyer's problem, not theirs. Well, just in conclusion, sports rules. And this is something I show you. Ohtani, the big star, one of the big stars of baseball. He's sort of their poster child right now. As you might have heard, he's been accused of violating major league rules by putting bets or having his translator put bets on sports, illegal bets on sports games, and maybe even bets on baseball games. Now, baseball rules are that, first of all, just an absolute blanket prohibition on betting on any baseball game. No player can do that. They also have a rule saying no player can bet on any sports event if the bet is illegal. And they placed bets with a California bookmaker, and that was in California, you can't do that. It's legal in most states, but it was illegal in California at the time. What's going to be done about it? Probably not very much. And this is part of the interaction of law again and sports. Can Major League Baseball has these rules, but can they enforce them properly? Well, we saw that with the Houston Astros. They were caught cheating, violating major league rules and that. And basically, Major League Baseball had this big investigation, and they slapped the Houston team on the wrist. They didn't suspend any of the players who were caught cheating. And why? Well, it's a practical thing. If they tried to come down hard and suspend the players and really punish the Houston Astros for their cheating, what would happen was the players and the club would sue them in a Houston court. And I can assure you, or Major League Baseball was afraid that if they got sued in a Houston court, the local jury would find that Major League Baseball had no authority to issue that punishment, to suspend the players, or basically to avoid the Astros World Series win that year. Major League Baseball in the cheating and performance enhancing drugs things was very cautious about trying to use its power to punish, because they knew if it ever gets into law courts, a local jury and a local judge are probably going to find against Major League Baseball, and so there'll be no punishment at all. And the cheating conduct will essentially be condoned under the law. So they want to avoid the courts in the first place in this case. And that's, I think, we're going to see in the Ohtani case too. This guy has a $700 million contract with the Los Angeles Dodgers, a 10-year contract. That's an awful lot of money for him. It's an awful lot of money for the Dodgers. Plus all the advertising that Major League Baseball has done, and they put this guy as one of the 5 players, you know, sort of the face of baseball right now. Maybe deservedly so, I'm not saying that. But awful lot of money involved, and are you going to suspend a player making that much and is that much the face of baseball over basically a technical violation of the rules? Now, we don't know all the facts involved here yet, but just know that the law is going to be prosecutors are going to be very practical about this. Major League Baseball is going to be very practical about it because they know the problems here. They know that baseball rules in some sense are ultra vires, which is another one of those fancy legal terms for saying sort of beyond the law or outside the law. And that is part of the reality of sports today. Well, with that, I've gone about an hour, which is what I'm going to figure is going to do. So I'd like to thank you for your attention. And if you have any questions or comments, you can sound out or ask Professor Walters or put it in the chat or whatever. So again, thank you for your attention today. Thank you.
Thank you so much, Bruce. This was fascinating. I mean, I'm just blown away by all of the different types of legal issues that can arise. Thank you so much. Any questions? I'm sure.
Good morning. I don't have a question. I just have a comment. Just to kind of piggyback off of what Professor Walter said, like this was very interesting. And didn't realize, like, you know, just like she said, the different facets or whatever involved. So thank you for opening our eyes to this issue. It's super cool.
Yeah, so I could speak for like 10 hours on this. So it's a lot more complicated even than that. And that's why Major League Baseball teams have lots of lawyers. And so lots of lawyers, lots of work for paralegals and lawyers. So you should be happy about all this.
And I love this, Bruce, because it really complements some of the lessons we talk about regarding stare decisis and standing and jurisdiction and venue. Really, there's so many different issues that complement our lessons in the program. So this was fantastic. Thank you.
One of the things I didn't mention, the venue of the remember that lawsuit against the White Sox?
Yes.
That was actually held in Milwaukee, Wisconsin. The White Sox Chicago White Sox were incorporated in Wisconsin, not in Illinois.
Oh,
And
wow.
so there was, so they had to sue them in Wisconsin.
Interesting. Oh, wow. Well,
Uh,
yeah.
the Comiskey family had a vacation home in Wisconsin, and at the time, and they had a Milwaukee minor league team, so they just incorporated in the state they were most familiar with.
Okay.
I suspect they're now incorporated in Chicago, Illinois, but at the time it was Wisconsin.
Oh, wow. That's interesting. All right. Well, thank you so much again. As a final note, I just want to encourage you all to register for Law Day, which is coming up on May 1st. I'll send an email out about it as well. I included it in the chat, the link to the Microsoft form to register. And anyone can participate, even if they're not a student here. The Illinois Appellate Court is coming to hear oral arguments at the college, and they haven't done this in quite a few years. And actually, one of my former colleagues is the assistant state's attorney who's giving the oral arguments on behalf of the state. It's a criminal case regarding a crankle issue, ineffective assistance of counsel. So it's going to be a really interesting case, and incorporating both, criminal law and law in general and appellate court issues. So I would encourage you to register for that. We'll have a mock crime scene. We'll have a lunch and learn with employment law, true crime podcast, court reporting. And then at night, we'll have a Zoom session with our universities that offer four-year transfer options for our students. So we'll have Roosevelt University, Loyola University, and Illinois State University will be joining us, and they'll tell you how all your credits can transfer to those colleges if you want to continue on for your bachelor's degree or beyond to law school, like some of you have made the choice to do. So, all right. Any other questions or concerns? But please register. Lunch will be provided. We're having Jimmy John's, so it'll be a good lunch. All right, thank you so much to Bruce. We are so grateful. This was fantastic. And I hope you all enjoy the rest of your weekend. Thank you.
Thank you. Professor Walters, can you stay on for one hot moment?
Yeah, absolutely.
Thank
Oh,
you.
who is doing the oral argument?
From the state, is that what you said?
Yes.
Oh, Andrew Yasan.
Oh, okay. Yeah. Okay.
Yeah,
I know Andy.
we started in the office together in 2008, so we've been good friends since then.
Okay.
Yeah.
All right. Well, have a good day.
Yeah, are you gonna come, Hannah? You gonna come
I
down?
am gonna come. I just registered for it. Andy. I help with the softball game, and I always help Andy. So
Oh, yeah.
I know Andy.
Oh my gosh, Ladonna, I played in that softball game for years.
I've been going every year.
Oh my gosh, it's such a
Um.
good time.
So yeah. Okay. Yes, and I did select that I would volunteer if there was any volunteer spots.
All right.
So,
And
okay.
Jason will be here for the transfer session from Illinois State. He's the one who's
Oh, okay.
yeah.
I graduate May 18th, and I don't want to hold you. I graduate May 18th. I'm taking my LSAT in July.
Oh my
And
gosh.
yes, so
Nice. Oh my gosh.
okay.
Okay.
All
Congratulations.
right. Bye.
That's amazing.
Thank you. Bye.
Okay. Okay. Yeah, you have some comments in the chat as well, Bruce. Thank you for the informative information. Carmela says, Angie says, thank you. It was fascinating. So, all right. All right.
Yes, thank you so much.
All right, Alex, what can I help you with?
Just wanted to just follow up with you, reference the expungement clinic.
Yes, I know.
Yes.
No, legal aid has not given me the case
Okay.
charts yet for those clients. You know what? I'll follow up with them on Monday though. Sometimes the problem is that we get the clients from the state's attorneys and the public defenders, but then when legal aid reaches out to them to get some additional information, they don't respond. The clients don't respond. So like there's kind of a lag in that. But usually they're pretty good about letting me know when they aren't getting that response so that I can reach out to the public defenders and say, hey, tell your client like they're reaching out to them so that we can get their cases expunged. It's not
Right.
like we're trying to solicit services. It's something they already asked us to do,
Right, yeah. No, I just wanted to make sure I didn't miss anything.
No, you didn't. You
Okay,
didn't.
okay. All right, cool, perfect.
Okay. Did
Thank
you
you
take
so
your
much.
LSAT yet? You were going to.
Yes, I took it. I'm retaking it actually next week.
Okay.
So
Awesome.
yeah,
All
just
right.
try not to go crazy.
Okay. Yeah. Take those practice tests.
I am.
They reuse those questions. So.
Yes.
All right.
Yeah. Thank you so much.
Thank you. Are you gonna come to Law Day? You are, right? You said?
Yes, yes,
Okay.
yes.
Okay.
Because the true crime is someone I know, right?
Yes, it is. I forgot about that connection. Yes, Mark and Jamie.
Yeah.
Yeah, Cal City.
Awesome.
Yeah.
Awesome.
And Mark's been a friend of mine, for years. Friends with my husband, like
Mhm.
randomly. So yeah. And when we
Yeah.
worked together, at the state's attorney, well,
Mhm.
he was at the state's attorney's office, but on cases, we would work
Yeah,
together.
yeah.
Yeah. Okay,
Well,
good.
thank you so much.
Thank you.
I'll see you soon.
All right.
Can I
Hi,
say something
Carla.
fast? I'm sorry.
Hey, Carla.
I thought it was a 10 o'clock class, but I'm going to review the recording.
Yes, I'll
Professor
send it out.
Allardice, Carla Rodriguez, I was in one of your classes and I really enjoyed your poli-sci class, but today's discussion on sports law, I have a passion for this as well. I had the privilege of working for a law firm that did player representation in hockey. They were part owner of the Chicago Wolves, and they had an affiliation also with the Reinsdorf family and White Sox. And so we were always involved in that kind of stuff. But you really broke it down when you would, I loved your passion for sports and your sports discussions before class. They were always fun. And your challenging questions to ask, stump the professor. Those were always fun. I was the one that came up with the question of Lyndon B. Johnson. Where did he teach in high school? And that was in Cotulla, Texas. And so your detailed information, I'm looking forward to getting more information on the recording, but your expertise in this has always pulled at my heartstrings, and I really appreciate that you took the time to talk to our class today. Thank you so much for your dedication to the school and to our program today. Thank you, Professor Walters, for having him. I'm so excited.
I know. It's good to see him back, right? Yeah.
Yeah, I wish we had this part of the curriculum, but I know he's really busy, and the curriculum has a lot to offer. But it's exciting to hear that. I hear a lot of folks that are going into this program, and I actually also talk about Professor Allardice and his information that he has provided. But thank you so much.
Thank you. And success in the legal profession. Yes.
Yes,
Thank
exactly.
you.
All right. Well, I have to run. I've got a birthday party to get to, but it was good to see you all. And thank you so much again, Bruce. We appreciate it.
Becky, we'll talk maybe a little later about some of those things that are going on at the school. Okay.
Yeah.
Okay.
Okay. Bye.
Thanks,